Estate Planning Secret Seminar, what some don't want you to know. My name is Attorney Edward Littlejohn. I'm the founding attorney and CEO at Littlejohn Law. And today we're going to be covering the Ohio Estate Planning Secret Strategies, some ins and outs of probate, and what your family can do today to protect your loved ones. If you have any questions, feel free to put them in the chat. I want this to be more of like a dialogue. So if you have some questions, go ahead and drop them in the chat. I'll be glad to answer those questions. If you're in the Facebook community, be sure to join the link for registration because I'm going to put on a PowerPoint presentation for everyone today so that you can see that. If you're really interested in seeing that, again, put your questions down into the chat. Put your questions into the chat. Like I said, my name is Attorney Edward Littlejohn, the founding attorney and CEO at Littlejohn Law. And the goal today is to kind of help everybody make a well-informed decision regarding protecting your family's future and giving your peace of mind, right? We see that very often that our clients come to us in a time when they're looking for some sort of peace of mind. They're looking to have their assets protected. And most importantly, they're looking to streamline the process for their loved ones. In fact, today I just met with two clients who were finalizing their estate plan and kind of getting things in order. And one of the things that they were both very happy about is the sense of relief to know that this has been taken care of and that their plans are in order. Again, our goal today is to just help you make well-informed decisions, and I want to guide you through the process. So we're going to cover three main topics today. Number one is, can we actually protect our family from court battles? Number two is, how do we make sure that our wishes are carried out? And number three are, what are the common misconceptions? And at the end of our presentation today, you'll be able to answer all of those questions. So the first thing that we always like to talk about is understanding the family dynamics, right? This is very important because each family has different dynamics. And so the number one thing that we like to do is identify who your loved ones are and kind of what your assets are. Today, one of the clients that I was meeting with had four biological children and two stepchildren. And for him, it was very important for the stepchildren to be included in the plan. So essentially, he had six children that he wanted in the plan. Now, what's important for everyone to remember is that if you truly love your family, you'll create a trust for them because the trust avoids probate altogether. Far too often, my team and I see families caught up in court battles because all they have is a will. And a common misconception that we see is people thinking a will alone is enough. You see, a will is a guideline for the probate court to follow. And depending on your family dynamics, you most likely will want to trust to make everything smooth on your family. So the first misconception that I want to put out there is that people think that everything has to go through probate court when they pass away. And the reality is everything doesn't have to go through probate court. It depends on how the asset is titled. So the first thing that we do is we look at those assets and we see how those assets are titled. If there's an asset that's titled in your name only, then that's considered a probate asset and an asset that must go through the probate court in order to transfer. A non-probate asset is an asset that's not titled in your name only and gets transferred as a matter of law, right? It gets transferred outside of the probate court. The most common non-probate asset that we see are life insurance policies. That's right, a life insurance policy. So a life insurance policy, it has a beneficiary designation, and all you have to do is provide the life insurance company with a copy of a death certificate, and it transfers automatically. Again, that is a non-probate asset, and the most common non-probate asset being a life insurance policy. And so what we do is we sit down with our clients and we identify how their assets are titled, and we discuss what would happen with those assets in the event that their loved one passes, right? So if you have a home that's in your name only, it's going through the probate court because we need the probate court to execute a new deed to transfer the property. Same for a vehicle. We need the probate court to transfer the vehicle. However, if the asset is in what we call survivorship or in a trust, then it could avoid the probate process altogether. So that's what we do. We help our clients avoid the probate process so that they could save money from going to the probate court, from going to attorneys, from going to other administrative fees, to keep more money in their families' pockets and to give them peace of mind. Which brings me to the common misconceptions. And I'm going to hit all of these real quick for you guys. The first misconception is, again, thinking that everything must go through probate court. It just depends on how the assets are titled. Like I said, most common life insurance policies are non-probate assets, but we can take all of your assets and turn them into non-probate asset. The second misconception is people think that there's enough time for planning. And the reality is there isn't enough time, right? You don't know when incapacity is going to strike. And if you have a plan in place now, it'll definitely protect your family. Number three is thinking that probate isn't that expensive. The reality is probate can cost anywhere from 5,000 upwards of 20 plus $1,000 on your loved ones. And the last misconception that we're going to be covering today is thinking that Medicare covers everything. And the reality is it doesn't. So let's start with the second misconception because we've already talked about probate assets versus non-probate assets and making sure those assets are titled properly. But the second misconception is thinking that there is enough time to get your affairs in order. So a couple years ago, I was working with a client who called me because her husband had had a stroke. And as a result of his stroke, she wanted to get on his business banking account so we could transfer some money and different things. And one of the things they did not have was a financial power of attorney and a healthcare power of attorney. Now, you might be thinking, well, this was his wife, so she could make any healthcare decisions that were necessary, and she could. But what she couldn't do was access the money that was in the business banking account, and that was their primary source of income. So she contacted our office, and we started to work on getting a guardianship appointed because they didn't have the power of attorney. In between her contacting us and us starting to work on the guardianship, her husband passed away. And it was a short period of time, about 2 weeks, he passed away. And here's what happened. If they had that power of attorney in place, then we would not have needed a legal guardian. And what we see far too often are people contact us and they're trying to get their guardianship set up because their loved one had a stroke or the loved one's in some sort of incapacitated state, but they're unable to do so because, as we all know, the scales of justice are swift, but they're also slow. And so what that means is it takes time to get through the legal process. If you have to get a guardian, here's what happens. You need a doctor to appoint and declare that you are incapacitated and unable to make decisions on your own behalf. And then you need the probate court to recognize that appointment and designation that you're in an incapacitated state. A couple years ago, my team and I were working on a case where it was a family member and their mom, some children, their mom was incapacitated and their dad was accused of abusing the mom. And so the children wanted to be appointed as their mom's legal guardian to make healthcare and financial decisions for her. And the father opposed it. And so we were in a court battle that ended up lasting almost 6 months. And before we got a ruling from the court, the mom had passed away. And again, if there was a power of attorney in place, the children could have acted without the probate court's authority. And so I say this all the time, if you really love your family, then you will get a power of attorney put in place, and you'll also get a trust put in place because this will allow you to have control over who you want to be in charge of your affairs, as opposed to the probate court looking at your family dynamics, deciding who should be the person in charge, and not following your wishes. In fact, that makes me think of another case that my team and I are currently working on, where a woman had a will, and the will was submitted through the probate court, and somebody else, another family member, contested the language in the will, and ultimately the probate court threw the entire will out. Now, what that means for this particular family is the deceased had plans on who she wanted all of her assets to go to. And one of those people who she had plans for was her daughter. But her and her daughter's relationship had been fractured, and all she wanted to do was give her daughter a 1/6 interest in her affairs. But since the will has been thrown out, her daughter is going to get 100% of her stuff. And that was not what she intended, especially because we had a will with her signature that the probate court has thrown out and not following her wishes. So if you truly want your wishes to be followed, then the best thing is to put together a trust so that your wishes can truly be followed. Let's see if there's any questions out there. Not seeing any yet. The next misconception is thinking that probate isn't going to cost that much. And so when we look at the real cost of probate in Ohio, what I like to tell people is that there are a few fees that get incurred. The first fee is the fiduciary fee. Now, the fiduciary fee under Ohio law, the fiduciary, so the administrator or the executor, is entitled to a fee of 4% for the first $100,000. Then they're entitled to 3% of everything from $100,000 to $400,000. And then they're entitled to 2% for everything over $400,000. So if we have an estate that is worth $250,000, which may be a house, car, bank account, maybe some retirement money of the sorts, if the estate $250,000, that's a fiduciary fee of $8,500 and an attorney fee of $8,500. Okay, so now that's almost $17,000 there. Court cost of approximately $400, and then a bond of $1,000. And so we're looking at about 18,500, give or take, maybe $19,000 in administrative fees. So almost $20,000 for assets that you've already decided who you want those assets to go to, right? This $20,000 fee is so somebody can collect the assets, and then the attorney can prepare the necessary documents to transfer those assets to your loved ones, right? What if you could avoid that fee altogether? And you can by setting up a trust. You see, a lot of times people say, oh, well, I heard trusts cost thousands and thousands of dollars. And in fact, they do. They're not cheap. But what they do is honor your wishes. What they do is keep your family out of probate. What they do is keep your family out of long litigation battles. You know, I was working on a case a couple weeks ago, and a client had said, "Well, how much have we spent fighting over this?" And they'd spent almost $20,000 arguing over who should receive what assets in the estate. And that money could have been better spent going to the loved ones. And so the real cost of probate is, like I said, almost $20,000 on a $250,000 estate, not to mention the fractured relationship between the survivors. Okay. the fractured relationship between the survivors. You know, far too often, my team and I are working on cases where siblings are no longer talking to each other because their loved ones passed away. Just really sad. And what we try to do is keep the peace. Again, we try to keep the peace to make sure that your loved ones are protected and that their assets go directly to the people that you wanted those assets to go to. Again, we've already identified the trusted advisors and kind of setting the goals. Again, these people are your financial power of attorneys, your healthcare power of attorneys, and your trustee, somebody that you trust to follow your wishes and to honor those wishes outside of the probate court. So, how does a guardianship work? A guardianship can cost anywhere from $5,000 to $15,000, and a guardianship is very comparable to a power of attorney. They're basically the same thing. Power of attorney, you get to pick the person you want to be in charge. Guardianship, somebody else gets to pick, and that person is somebody designated by the probate court. The last misconception that we see is thinking that Medicare will cover everything. And the first thing to kind of understand is Medicare is available for any Ohio resident that is 65 or older. Medicaid is a state and federally funded program that covers the elderly as well as people in low income brackets, tax brackets. So, one of the things that happens all the time is I'll talk to people and say, okay, did your loved one have Medicaid or Medicare? And they say, oh, no, no, I'm on Medicare, not Medicaid. And one of the reasons why we ask that is because people don't realize that in the event that you go into a nursing home or a nursing home facility, Medicare only covers the first 100 days in a skilled nursing home facility. Okay. So, what that means is if you are in there with some sort of chronic illness where this is reoccurring, right? It's not acute, but it's more chronic. Medicare will not cover anything beyond the 100 day. And so that leaves families in a situation where they have to pay for their care out of pocket, or they have to look to see if they had long term care insurance. And so if you are paying out of pocket, the fees in Ohio range anywhere from $8,000 to $12,000 per month. So imagine you had a nest egg of $100,000. In 12 months, you've used $96,000 in nursing home care. And so, what my team and I do is we help people legally and strategically protect their hard earned assets. We help families that want to give their loved ones peace of mind, that don't want to spend all of their assets on their care, legally transfer those assets into a trust to keep those assets protected, right? That's what my team and I do. So when it comes to Medicare and long-term care planning, we transfer your assets into what's called a Medicaid Asset Protection Trust. Now, this trust is a special type of trust that will keep your assets out of probate and also protect against the rising cost of long-term care. Last year, the average cost was anywhere from $7,000 to $9,000 per month. This year, they projected it'll be from anywhere from $8,000 to $12,000 per month. So what we're trying to help families do is some proactive planning. Again, on an estate worth $250,000, we already discussed there will be almost $20,000 in administrative fees. Imagine if your loved one spent $100,000 on the nursing home care, and then now there's another $100,000 that's left to your family. What if you could keep that money? What if you could keep that money? Let's see if there's any questions out there. Any questions out there? Looks like we have a question. Let's see. Who has control of the funds that are placed in a Medicaid asset protection trust? Great question. The assets that are placed in a Medicaid asset protection trust are controlled by the trustee. So, what my team and I do is we work with you to identify who you want to be your trustee. And then we create the plan, and then the trustee has to follow the plan as it relates to those assets. So, the name on the bank account would be the trust, and the person who would have access to the bank account would be the trustee. The person who would be able to transfer the property would be the trustee. Upon your death, the trustee would carry out the plan that was laid out. Now, just today, my team and I were talking to a client who their father had a trust, he did the right thing, he got a trust, but they don't agree with his plan, right? His plan was for the assets in the trust to be sold and then given to the children. But the children do not agree with the plan. Again, because it's in a trust, the trustee has to follow the trust, and the trustee has to abide by the wishes of the person who created the trust. Now, once a trust is created, we focus on drafting, making sure it's properly executed, and then funding the trust. Now, a lot of people always ask me, well, what do you mean funding the trust? What does that have to do with anything? Well, the trust only works for assets that are properly titled in the name of the trust. Just like at the beginning, we were talking about probate assets and non-probate assets, and depending on how those assets were titled, dictates what happens to the assets. One of the things that we have to do is make sure that your assets are properly titled in the name of your trust to be controlled by your trust. Okay. All right. Let's see if we got any more questions. Oh, great question. Oh, great question. What is a survivorship deed or a transfer on death designation? Excellent. So a survivorship deed is very similar to a trust in that it allows an asset to avoid probate court. Same for a transfer on death designation, both of which allow assets to transfer outside of probate. Now, the biggest difference between the two are the level of protection that they give. You see, any asset that has been transferred into the Medicaid Asset Protection Trust and is outside of the 5 year look back period is protected. But if you have a home or another asset in survivorship, or you want to do a transfer on death designation, you still own that asset. And as a result of you still owning that asset, if you go into the nursing home, they can make a claim against those assets that you own at the time that you enter into a nursing home. I've had worked with some people who said, well, I don't want to do survivorship. I don't want to do transfer on death. I've heard of something else called a life estate. Can I do a life estate? And a life estate is a special type of deed where you convey the property to someone else, but you retain the right to live in the property for life. So a life estate is very effective. However, in the event that you have to go into a nursing home, they put a value on your life estate. They say, well, you're X amount of years old. Here's how long we expect you to live. There's an actuary table that says the property that's worth $100,000 based on this age, this is how long they're going to live. We're going to use this multiplier. So here's how much that life estate is worth. And a common misconception is people think that you're going to get kicked out of the nursing home. You're not kicked out of the nursing home, but you are required to be private pay for a period of time. And so that private pay period could be 3 months, maybe your private pay for a year. It just really all depends. Also, Medicaid Again, they don't kick you out of your home, but what they will do is make a claim against your estate. So we've worked with many clients whose loved one didn't do any planning. And when they passed away, Medicaid made a claim against their estate for reimbursement of the nursing home cost. I can remember one client in particular, this would have been almost 10 years ago now. His mom had passed away, and um, she'd been on Medicaid for a long time, but their home was worth less than $50,000, and there was a $200,000 Medicaid claim on the house. And so you could see that home would not go to the loved ones because Medicaid was making a claim worth more than the actual value of the home. But because there are certain exemptions and exceptions, which we were able to apply in this particular case, we were able to keep the home and to get Medicaid to waive their claim for the $200,000 claim on the house. So we were able to protect that family. So here's what you need to do. If you are ready to get started, then you should schedule a complimentary estate planning needs assessment with our team so that we can answer any additional questions that you have and so that we can help you put your plan together. The other thing to remember is during your needs assessment, we're going to go over the 4 critical documents that all families in Ohio need. Number one being a trust. Now, there are a couple different types of trust. One's a living trust, one's an irrevocable trust. And depending on your goals, my team and I will be able to let you know specifically what type of trust is the best trust for you and your family. The second thing that you'll need is a healthcare power of attorney and a financial power of attorney. These allow someone else to make healthcare and financial decisions for you in the event that you cannot make those decisions for yourself. And it's critical that we get that healthcare and financial power of attorney in place. The fourth document that you need is a pour over will. Now, a pour over will is a special type of will that allows your assets to get transferred into your trust. And so it gives the probate court the limited jurisdiction over the asset to transfer it into your trust only, as opposed to administering it and triggering all those fees. Okay. Looks like we have a couple more questions here. All righty. Can a fiduciary slash administrator request payment, then accept only partial payment if it may cause liquidation of the assets the family would like to keep, or accept assets the family would like to keep as payment, such as vehicles? Could you elaborate on that a little bit more? That question there? Can a fiduciary accept payment? All right, maybe what's being asked is whether or not a fiduciary can accept partial payment when settling the estate. And here's what I can say. Generally speaking, there's going to be um, the probate process is going to last anywhere from 9 to 12 months. Now, the way the process gets started is somebody gets appointed as a fiduciary, being the executor or administrator of the estate. And the probate court has 90 days to appoint someone as that fiduciary. Once the probate court appoints them as a fiduciary, I like to say that there's another 90 days when the fiduciary then has to do an inventory an appraisal of all of the probate assets. So they have to identify all of the probate assets for the estate. Once those assets are identified, normally another 90 days, the administrator or the fiduciary has to do an accounting to say, here's what the assets are, here's what assets I have in my possession. I plan on distributing these assets this way. Probate court, will you give me approval and permission to distribute the assets? So I think this question is saying we're at a point where we want to distribute the assets and a family member wants to purchase an asset or they want an asset in lieu of in lieu of their inheritance. So we do see this quite frequently where maybe there's a car and there's two siblings and one sibling doesn't need a car. So they will allow the other sibling to get the car in exchange for more money. So one sibling receives more money, one sibling receives a car, and as long as the exchange is of equal value, probate court has no issue. We've also seen situations where a party executes a disclaimer. And in the disclaimer, what that is a legal document that indicates that you do not want to receive what you're legally entitled to. So we've had situations where families executed a disclaimer. They said, I don't want this asset. And once they don't get the asset that they want, it goes to the other person. If this question is saying, hey, can I accept some other assets? Typically, what we'll do is if there's any deviation between what should happen, the parties will sign a family settlement agreement. Now, keep in mind the probate court, they want to do whatever is simplest. And let me explain that a little bit more. The simplest thing for the probate court to do would be to take a piece of real estate that's owned by the deceased and put it in the names of the three children or four children, right? That's the simplest thing for the probate court to do. The simplest thing would be for a vehicle, even though we know three people aren't going to be able to drive it, the probate court will issue a new title in all three people's names if there's no agreement. That's the simplest thing for the probate court to do. So if you're looking to kind of get around that, there's going to have to be some agreement amongst the parties that the probate court would honor. Okay. Let's see. Hopefully that answers your questions. In the link in the chat, I dropped a link for a complementary estate planning and probate needs assessment with my team. This normally lasts between 15 and 20 minutes, and we'll be able to answer your questions and get you on to a path of success. Okay, we'll be able to get you on to a path of success. See, are there any other questions out there? Oh, going once, going twice. All right, now keep in mind, if you found this helpful, one of the most helpful things that you could do for our team is to go online and leave us a Google review and just express that you attended a seminar. And let me know what you thought about the seminar. Was it informative? Was it helpful? Did we separate any fact from fiction? And if you are feeling a little bit more confident, schedule a complimentary estate planning or probate needs assessment with our team. And remember, where there's a will, there's a way. Where there's no will, then there's probate. But the best plan is a trust plan. And I'm your trust man. Have a great day, guys.